right, so hello and welcome to Encouraging Use and Reuse of Your Collections with WriteStatements.org. So WriteStatements.org is a joint initiative of Europeana and the Digital Public Library of America to enable libraries, archives, and other cultural heritage institutions to help everyone engage with their online digital content by providing simple and standardized terms to summarize the copyright status of works and how these works can be shared. We have three panelists today who are all deeply involved in the development of WriteStatements.org. Starting with Emily Gore, who's the Director of for Content of the Digital Public Library of America. Before joining DPLA, Emily served as Associate Dean for Digital Scholarship and Technology at Florida State University Libraries. Emily's 15-year career in libraries has focused on building digital collection collaborations. She has a Master's of Library and Information Science from the University of Alabama, a Bachelor of Arts from Clemson University, and is a 2011 graduate of the Frye Leadership Institute. Emily co-chaired the Write Statements Working Group. And I'll just introduce everybody now and then let them take it away in a minute. Greg Cram is the Associate Director of Copyright and Information Policy at the New York Public Library, where he works to make the library's collections broadly available to researchers and the public. Greg has helped steer projects through a maze of complex intellectual property issues, including the release of more than 197,000 high-resolution images of public domain collection material. He's a graduate of Boston University and the Cardozo School of Law and a licensed attorney in New York and Massachusetts. Greg served on the Write Statements Working Group. And finally, Mark Matienzo. Mark is the Collaboration and Interoperability Architect at Stanford University Libraries. Before joining Stanford, Mark was the Director of Technology for the DPLA and worked as an archivist and technologist at institutions including the Yale University Library, the New York Public Library, and the American Institute of Physics. Mark received a Master of Science in Information from the University of Michigan School of Information and a Bachelor of Arts in Philosophy from the College of Worcester. Mark chaired the technical working group for WriteStatements.org. Melissa Fournier, I'm chair of the Intellectual Property SIG and manager of Imaging Services and Intellectual Property at Yale Center for British Arts. And I'm just going to step aside and let them tell you more. Thanks.
Awesome. Thanks, Melissa, and thanks for asking us to do this. We're excited to be here. I'm just going to jump right in since we're already a little behind time. So just to start with, I'm going to kind of talk about why it is that we needed write statements. You probably already know, but I'll just show you some lovely examples. But so this is the Digital Public Library of America's network. It's a diagram of our network. We have two kinds of hubs, way you contribute content. So the yellow dots here represent content hubs. They're institutions that work with us on a one-to-one basis, like the Smithsonian or the National Archives. And then you have orange dots, which are our state hubs or regional hubs that we call service hubs, and they represent a one-to-many relationship. So in many of our states, we have over 200 small organizations participating statewide that their data gets aggregated and sent up to DPLA. So some of those institutions, you'll just see the logos here. We've got so many now I can't fit the logos on a screen, so this is just a random smattering of the institution logos, but many of which you'll recognize. You see the lion from New York Public Library and many others. Right now, this is the state of the current hubs map, so where we actually have hubs that are contributing content to the Digital Public Library of America. So all of the areas in orange or the yellow dots or the burnt orange, all of those are actually live. They have content in the DPLA, and it's already live and up. Anything in Navy you see has been accepted, and they're working to prepare their data. So many of the folks in Navy, we actually have a couple that are getting ready to be live. So we'll move those over to orange. This is purposefully not red. So people keep saying, you might need to change your colors. I'm like, you're my right. Anyway. So, and the yellow dots are those content hubs throughout the country. You'll see a bunch of those in Washington, D.C., a number I've mentioned already that we work with directly. So a little bit by the numbers, we have over 14 million records right now. We have 31 hubs and 11 hubs in development. We have over 2,200 contributing institutions. So when I talked about those states and how they work with a lot of small institutions in their states, that's where that number comes from. So many cultural heritage institutions throughout the country contributing data. We deal with 9 major metadata schemas that are not all in XML. So we deal with lots of different data models and schemas that come to us that we then convert to our metadata application profile. One of the things that we require in our metadata application profile is a rights statement. And there are a lot of them. We actually have been able to kind of do some measurement and determine that there are probably over 100,000 different rights statements in the 14 million records we have now. And I always find this to be hilarious, this last point. There are more words in the rights statements field than there are in any other field, including description, folks. We like to say a lot about rights. And maybe we don't say a lot about rights at all, but we like to say a lot in the rights field. Yes, we do. I'm going to show you some lovely examples of that. All right. So a gentleman named Dean Farrell, who is at the University of North Carolina at Chapel Hill, he likes to do visualizations with data. He took 1.3 million records, a sample set out of the DPLA, and he created this visualization here. So what this is it kind of groups the right statements into categories. I know you would have to like have a serious glass to read this, so I'm going to read it for you. I'm going to tell you what it means. You can trust me. In the dark orange in the top, those are items that actually have Creative Commons license in the DPLA. So they clearly have in their rights field that there is a Creative Commons license. So a small amount. Here in the light orange, where you see a lot more, you see lots of little tiny boxes. This is the digital, this is copyright, either copyright, all rights reserved, copyright a specific date, some sort of in copyright situation going on with the orange, identified in the rights statement. In the light blue, that's all that you'll find that says public domain or unrestricted. So some sort of this is free and open is what's in the light blue. In the dark blue, we don't know what it means. It's hard to figure out exactly what the right status is from what is written in the field, right? Yes. Anyway, there are some crazy statements in there. A lot of generic boilerplate statements. You may have used one of those. You may have written one of those over time. I have. It's all good. It just happens. Sometimes it's what we get advised to do, and we say, okay. So this is just another quick analysis that we did of right statements in the DPLA using similar amount of records. So 45% are actually copyright or all rights reserved. They're identified in that way. The 25% is the we're not real sure, the other part. 8% listed as government documents, but not clearly listed as public domain. So not necessarily are they identified as public domain, but they say they're GovDocs. 7% missing a right statement, so some people don't follow the rules, and sometimes we let them fall through the cracks. This happens. And then 7% also say, this digital image copyright. Y'all seen that, yeah? Put something on a scanner, press the button, and you get a new copyright. And so you say, oh, no, today this has a copyright of 2016 because I digitized it today. So we've got 7% in there with that. We've got 5% in public domain, so we have more this digital image copyright than we do identified as public domain, and we have 3% as Creative Commons license. Okay, let's look at some statements. Imagine for just a minute, maybe you don't have to think too hard, that you're actually a user of these collections. Folks, this is a right statement. This is a right statement found in the DPLA. I didn't even put the actual object here because the screen was not big enough to show you the object as well as the right statement. But this right statement tells us a lot, right? Okay, so it tells us C, 2002. Brigham Young University, all rights, anybody from BYU, I'm sorry. All rights reserved, I don't mean to pick on you. There are other people I'm picking on too. The information available on this site, including any text, computer codes, data, artwork, video, audio, images, and graphics, collectively called the material, may be protected by copyright. Maybe. It may not be either. We're just telling you here. There's a lot of stuff we're telling you here. It's a long way to say use this stuff at your own risk. Make sure you call us first. And then here down at the bottom, pending public. Maybe they really meant to say not public. I don't know. Anyway, long right statements. Not the only one. Okay, here is a record that I was able to show you here. This is a map from 1787. 1787, yes. What does the right statement say? Digital copyright 2013. 1787, yes. Yes. Yep. I don't think we have any question about the right status of a map from 1787 at this juncture, but apparently there is. Here we go with another one. So this is from one of our museums, the Missouri History Museum. So their right statement doesn't say anything. It says, for rights relating to this resource, go ahead and click here and visit the resource. Okay, so we're going to tell you anything on DPLA, but we're going to point you somewhere else. And when we get there, we are going to tell you that this letter from 1863 has a copyright of 2009. Missouri History Museum. Yes, it does. Yes, we do. Yep. All right. Here's a little tricky one, but y'all are smart, and I bet it's not too tricky. So first of all, the copyright in the title, it just tears me up. But we have a lot of people doing that. I was able to pull up like 5 or 6 records that like right there in the title says copyright so-and-so. It's not the title of the work, it's like, boom, copyright. So anyway, interesting title here that clearly says copyright 1931. But when you go to the right statement, what's there? It's a Creative Commons license. Why is that a problem? Anyone?
Because the institution probably didn't have the rights to begin with and they assigned a license.
That's right. So you need to be the rights holder to assign a Creative Commons license, or the rights holder needs to give you those rights to assign a Creative Commons license. So in this particular case, my guess is that Joe Mara probably did not give David Rumsey, though we love him, probably did not give him the Creative Commons license for this material here. So the copyright 1931 would have been the correct rights assessment as opposed to putting a Creative Commons license on the material. Here we go again with copyright in the title. Pillars of Hercules from 1899. We see these a lot. Some materials in these collections may be protected by U.S. copyright law. It's basically, it just basically is a boilerplate text, but it tells you nothing about the actual item that you're looking at. No analysis has actually been done of the item. It is just a boom, here's this, and we haven't told you anywhere in the metadata record about the date. Nowhere in the metadata record except for the title. There is a field for date, but we didn't use it here. We just put copyright 1899 in the title, okay? Very similar thing here from the Minnesota Historical Society, using a URL for a right statement, and that's what you get. So again, very like all comprehensive, pretty much says we own everything. Call us if you want to use it, we own everything. So this is a problem, and when people find things online, even if they're in the public domain, they have no way of knowing that because we're not telling them a whole lot in these right statements. So see why we need standardized right statements from Johnny Appleseed? Yes. The principles of the statements, so what we decided to do is put together some standardized right statements. So Europeana has done this for a little while. They had built a licensing framework themselves for their collections, and we started knowing that they had built a licensing framework, but also knowing that DPLA needed to use a licensing framework, and we wanted to build something that other countries could come on and where it could be universal, so it doesn't matter, so we didn't have to build, each country has to build our own licensing framework. So the concept here is that we were trying to build something that was international in scope and that could follow these principles, that could be simple, flexible, descriptive, accurate, and I do repeat there, did I say accurate? Because we really think applying these things accurately is the key. So not just choosing a statement because it's standardized, but doing it in an as accurate way possible with the amount of information that you've got, and then being transparent as part of the whole process was a real key for us. So these were the working group leaders, and I'm going to turn it over to Greg to talk about the actual statements themselves and a little bit about some work that NYPL is doing. Here you go. Clicker. Our name either.
Do you have the?
Just right there.
Okay. All right, so as Emily said, there were some different categories that we could see coming out of the analysis that we've done over what was already in DPLA. So we were looking at what kind of statements were already there and ended up deciding that we could use that as a way to break down what was already in existence. So there are three categories of right statements that we created. There's the in-copyright statements, the no-copyright statements, and then a set of other statements. So I'm going to walk through each of the statements, and then I'm going to hand it off to Mark to talk about the technical side of this, and then we'll talk to Emily then, and then back to me. So we're going to do a little bit of a laptop shift here. So we'll start off with the in-copyright statements. And these statements should be applied to works that are still protected by copyright law. And by work, I actually mean the underlying work, the work that's being photographed. As Emily pointed out, in all cases, these statements assume that no new rights are being created in the digitization process of two-dimensional materials, at least not in the US. As the display at your own risk project found, some cultural heritage institutions believe that they own a separate copyright in the photo they take of an object, and we just simply disagree. In the US, no new rights are being created in slavish reproductions of two-dimensional items. No new creative or original works are created by simply accurately reproducing those items. So the right statements take as an assumption at the very beginning that no new rights are being created when things are shot on stands like these. So we'll start at the beginning of the in-copyright statements. The first one is the very vanilla in copyright. It's exactly what it sounds like. The item is in copyright. That's easy. Next one's a little bit more tricky, the EU Orphan Work Statement. It means the item has been determined or identified to be protected by copyright law, but it's also been identified to be an orphan work under the terms of the EU Orphan Works Directive. And this statement's really targeted at our friends in Europe, especially at Europeana, who can take advantage of this EU directive around orphan works. For those of us who don't get to take advantage of the EU directive, we have a third statement, an in-copyright statement that is unknown rights holder. It means the item's been identified as being in copyright, but that its rights holders can't be located or identified after a reasonable search. Generally, orphan works, this will apply to orphan works in countries where there isn't the EU directive. The last two in copyright statements are around educational use and non-commercial uses. And these statements are there for when an institution has worked with the rights holder to permit the institution to make these items available for downstream uses by our users for educational or non-commercial uses. It sounds a little bit like a Creative Commons license, but this is a little bit different in that there's not a Creative Commons license attached to this item, but there is some agreement between the institution and the rights holder to enable downstream uses of these items. So now we get into the out of copyright works, the ones that are in the public domain. The first one is contractual restrictions apply. So this means the work is in the public domain, but that the organization that's making it available is somehow contractually required to restrict certain forms of downstream uses by third parties. Often we see this in archival contexts, but even in museum contexts where there are donor agreements or digitization agreements that prevent the institution from making that public domain item fully available to downstream users. The second out of copyright statement is the non-commercial use only statement. This means that the work is in the public domain, but that the organization is contractually required to restrict all uses of downstream users except for non-commercial uses. This statement's really specific to one instance in Europe around the Google Books project, so we don't anticipate any US institution using this, but it's there in case they sign some bad deal that makes them do this. The third non-public domain statement is other legal restrictions apply. It means that the work is in the public domain, but there are some restrictions, some known restrictions imposed on the institution or on the use of that item by something other than copyright, something similar to copyright that somehow restricts the use of that item. Again, this is targeted at institutions outside the US who have laws that protect things like traditional cultural expression or other kind of copyright-like things, but not exactly copyright. And the fourth statement, fourth public domain statement is no copyright US. You might wonder why a very globally focused project has a US statement. This statement means that the item has been identified to be in the public domain, at least under the laws of the US. And although we wanted these statements to apply globally, we had a single or somewhat of a problem. And that's because there isn't a single global copyright law out there. Instead, we have about 200 or so different national copyright laws that have different durations in their laws. The US, though, is somewhat unique in the way that we determine the copyright status of assets, of items, especially those items before 1964, 1976. That is in part because we had formalities in the US when most other countries had abandoned those formalities. So there's a special statement for the US institutions who have identified works that are in the public domain even all the way through 1989, but are maybe still in copyright in other countries. The last set of statements, our squishy statements, are the kind of undetermined statements. The first one is no known copyright. It means that the institution believes that no copyright currently exists in the item, but that they weren't able to reach a conclusive determination that they felt comfortable with. In the US, this is really useful for archival collections with older material where the publication status of these assets is somewhat difficult to determine. It's a good way for the institution to signal they don't believe there's a risk here, but they may need to hedge a little bit. The second statement is copyright not evaluated. This means that the institution who's making this item available has not even looked at the copyright status of the asset. Little red flags might be popping up in your heads. That might be a little bit of a flag that you might be concerned with. We certainly are a little bit concerned with this statement. Certainly there are institutions who need this statement because they will make a determination about the fair use of their assets, at least in the US, and not really have to look at the copyright status because even if the items are in copyright, they may have a fair use claim there that would obviate the need to worry about the copyright status. Finally, there's the copyright undetermined statement, the most squishiest and kind of useless for our users of all. But it means that we've looked at the copyright status of this asset, but weren't able to make a conclusive determination either way, or weren't in fact even able to make a determination. We just simply are missing key information. So each of these statements have some additional notices, and they're there to keep our lawyers happy. our General's Counsel happy. The first notice is there's no warranties. So when an institution puts a statement out there, they're not making a representation or warranty about that. That means if the institution gets it wrong, they're not going to suffer legal consequences, or hopefully not going to suffer legal consequences from the user's use of those items. The second is that there may be other rights at play. These rights statements were targeted at copyright issues, not at other things like rights of privacy or publicity, moral rights or trademark rights, rights that just simply were it would have been too difficult for us to include all of that into a single statement. And finally, there's an opportunity for some additional information to be provided on the institution's website. So long as that information doesn't contradict what is in the rights statement, that additional information is out there. Where we see this going is that many institutions, for example mine, at some point will start making the information we use to make that determination, that copyright status determination, more available. So if we think an item is in the public domain in the US because it's a US government work, we will indicate that as much in our rights metadata. So I'll go back to this statement. So there's this quadrant, small little quadrant in the upper left of this, and that's for the Creative Commons statements, the Creative Commons licenses. Now, rights statements in Creative Commons are meant to live near each other and next to each other and work with each other, but they are distinct things. And that's because Creative Commons are licenses applied by a rights holder, not by an institution who's identifying the copyright status of that work. In most cases, the person who's making the Creative Commons license, applying the Creative Commons license, is not, in fact, the institution making that asset available. CC also has some non-licensed tools that will be accepted by aggregators like DPLA and Europeana. For example, there's a variant of a CC license. It's not exactly a license, but instead a waiver of rights, and that's CC0. It's otherwise known as the public domain dedication. If you are an institution who have signed on to DPLA, you will be asked to waive any and all rights you might have in metadata using a CC0 device. That's so that we can have interoperable data, and while there's likely no copyright in much of the descriptive metadata that we write, the CC0 is there to help eliminate that risk and that concern that other users may have. Another CC tool we are using is the original public domain statement from Creative Commons. This means if you see this statement, this icon, it means that the work has been identified as being free of known legal restrictions under copyright law, and CC tells us that this is meant to apply to very old works that are in the public domain in every country. That's a little tricky for us, but this is the plain vanilla public domain statement. So these are the list of statements that we anticipate DPLA hubs using when they use these statements. And in fact, all of the hubs will be required to use one of these statements with their objects going forward. So I'm going to hand it over to Mark to talk a little bit about the technical side of rights statements.
Okay, so I am and was the co-chair of the technical working group. So as you've started to hear, a lot of the work that we've done has been pretty highly collaborative. So I'm going to talk not only about some of the technical work specifically we did, but how we did it. So Emily touched a little bit on some analysis that we've done at DPLA, and I'll go into that in a little bit more depth, just to give you a quick overview of analysis that we did about 2 years ago, and so what Emily presented is an updated version of that. I'm also going to, as I indicated, I'll be talking a little bit about our development process and how the group worked together, details about the deliverables that we put together, and sort of what the ongoing impact of some of this work is. If you are incredibly lost, especially if I start to get into technical details, please just wave your hand or shout or frown or something, because I would like to I would like to make sure that folks understand what I'm about to delve into, and I don't want to make it too dry. So Europeana did some of its own analysis into the right statements when they were working on implementing the Europeana licensing framework. And we started doing our own analysis at DPLA about 2 years ago when we were first sort of getting started with the work on rightstatements.org. So in part, this work helped us evaluate some of the challenges that we might face with both implementation of a set of right statements as well as informing some of the requirements that we worked on as part of the technical implementation. So this work that we did was based on a then current corpus of 8 million records. So we created a report out of our backend system, got a bunch of JSON objects out that had a row for each distinct right statement per hub and the associated contributing institution. We sort of winnowed this down into a smaller data set that was expressed in CSV and did a whole bunch of processing in OpenRefine. And we went through a process to try to normalize these right statements against each other as much as possible. So doing things like eliminating differences like in copyright year, punctuation, white space, and things like that. So what this ended up leading us to find is that we had in that data set over 87,000 unique right statements. And again, those are not totally guaranteed to be unique. There is a degree of reduction of difference. So these are sort of a roughly similar breakdown as to what Emily talked about in her part of the presentation. And while Emily was happy to name names in embarrassing some of our members of our community, I will give a couple of examples that she didn't provide, which actually remain anonymous, and I'm not actually sure are still in DPLA. But this one, by far, is one of my favorites. Copyright person's name. I redacted the person's name. In the public domain, use of this object is governed by a CC by NC ND license. So can anybody tell me what's wrong with this?
So many things.
Just one. These are three different statements. Yes, so these are three different statements. And if you are, a K through 12 educator or a college student, even somebody who works in the cultural heritage sector, can you tell me what the hell are you supposed to do with this item and how can you do anything with this? This one is a little bit more complicated, and it's also confusing, but one thing I will note about this example, which says audio file copyright redacted. Again, that was a person's name. Creative Commons Attribution Non-Commercial No Derivatives 2.5 license, the URI for the license itself, public domain, photo courtesy of redacted, image retrieved from redacted. So this was an interesting case. This was actually a multi-part object. The description of the object was for a field recording of birds. But there was a description of the photograph that was a picture of this, whatever species of bird this actually was, that was actually subject to a different set of intellectual property requirements. So, I think we started to see there are actually larger issues than just ambiguity, especially when you deal with institutions that are doing aggregation of metadata in their own right, that you have these complex digital objects which might have multiple copyright statuses depending on what part you're actually talking about. So as a platform, as an aggregator, you still can't particularly give good guidance unless you have a degree of structured data that you're working from. So even though we were a little silly to demonstrate some of these egregious, when we were going through these egregious examples, I think these sorts of things really establish the why for our project. So I'm going to be talking about the who and the how, specifically on the technical side. So the technical working group had a good number of people on it, and involved a number of invited guests from the community who worked on related concerns. So these are people who had backgrounds in data modeling, vocabulary development, digital library or digital asset management system design, and just sort of general web development as well. And while they were not formally part of the working group, I'd also like to acknowledge the work of our contractors, Felix Ostrovsky and Adrian Pohl, who helped build the infrastructure that we're actually using to host the right statements. So one thing I think it's kind of important to note is that the membership of the technical working group in particular grew over time, and it has not been static. Much of the change in membership, or sort of the growth in particular, came about because we realized that there was work happening in related communities. One specific aspect was that there was similar work in investigating how to document rights statuses within the community around something called the Hydra Project. So Hydra Project is an open source community that's focused on building a framework to support digital asset management, mostly but not exclusively in academic libraries. So one of the things that we saw is there was actually a whole lot of important work happening at other institutions or on other collaborative projects. One was the Oregon Digital Project, which is a collaboration between University of Oregon and Oregon State University, and University of California, San Diego. So they were doing a lot of work to document and model rights statuses in a similar way, like originally based on the Europeana licensing framework. So in addition, I'd also say that this helped us identify specific people within those communities that were doing this work. So throughout that work that we did, we really met and communicated pretty regularly. We used a lot of collaborative tools, conference calls, Google Docs, Basecamp, and so forth. And really, one of the norms that quickly came up for us is that we had to be incredibly transparent about our work, both transparent with the larger rights statements working group, in addition to the community. So part of the work that we did was to actually develop a white paper that was sort of an early draft of our technical thinking. I will note that the rights statements working group did the same sort of work, but I think given the fact that we realized that we were actually in the process of developing a vocabulary, something that would be treated as, hopefully as a technical standard, that we really needed to be transparent about that work up front. We quickly also discovered that we actually needed clear feedback periods that had very strong deadlines, because people are busy, and even people in the working group kind of quickly sort of lost the thread if we didn't have clearly defined phases. Finally, there are sort of two sort of interesting aspects of this sort of that are not exactly in conflict with one another. So related to the transparency process, we really needed to have an open process, RFP process, to make sure that the community knew what our design requirements were, and ultimately to get people to respond to the work that we were doing. At the same time, while a lot of our communication was informal within the group, and especially as we worked out with the community, sometimes we had to actually fall back on formal channels. So the link that I actually have on the slide is a technical memo that I wrote to other members of the technical working group when we had a really, really contentious discussion. And I'm not going to get into details just for the sake of time, but you can read it if you really care about things like HTTP range 14. And if you know what that is, then you either really will or really not want to read that memo. So let's talk about deliverables and implementation. So we had the white papers, as I described. We had a vocabulary based on the resource description framework and a data model for expressing the right statements, published as linked data, a web application to serve those, and an associated content management system. So as I discussed, the technical working group developed these series of white papers. One, again, was this sort of initial trial balloon, which outlined our technical concepts. And then we now have 2 revisions and are working on completing a 3rd revision of the actual requirements that serve as the specification for what we've implemented. The reason why we've had multiple revisions is as we've gone through the process, we've actually realized that there are the requirements around things like versioning the right statements themselves have gotten clearer as we've realized that we've needed to make changes to them. We haven't gone through a full change process, but this has really helped us to elucidate the fact that we actually needed a very clearly documented editorial process. So Emily touched on the design principles, and these are just to remind you that the design principles overall for the right statements were simple, flexible, descriptive, accurate, and transparent. And these ultimately informed our technical principles. So the first is that the work that we did on the implementation and for the data model should reflect the right statements with minimal ontological commitments. I'm not going to get into the weeds about what that means, but basically we want to be opinionated enough that we're modeling the right statements correctly without, if you're doing a complicated linked data project or developing your own ontology, we want to not overly pollute what our view of the world, or your view of the world with ours. So if you run into a problem and you're doing work, trying to express your data as C.CRM and our right statements are not working, we need to know that. We also wanted to publish the right statements according to best practices for linked data. So part of this is there are an established set of norms around how vocabulary should be easily dereferenceable. So how does a web server actually behave when you request it if you're a machine versus if you're a person wanting to look at just a web page? The third is to design for extensibility. So to make sure that we had a framework to implement the right statements on, that if there were additional changes, we weren't going to have to throw everything out with the next revision, and finally to focus on the ease of implementation. The right statements data model fundamentally has this sort of center notion of this thing that we identify as a right statement. In our vocabulary, all these right statements are identified by URIs. So just like a URI like you've seen on screen already. And so these URIs are part of a concept scheme. So in addition, the classification groups that Greg talked about are considered to be are individual collections of terms. So when you want to actually apply one of the right statements, you have this thing which could describe an intellectual work, it could describe a digital object, but then you just associate it with, in our model, with the thing that identifies that other thing. A lot of the work we did was to really reuse existing vocabularies and align the work our model with existing vocabularies. So we incorporated properties in our model from things like the Creative Commons rights expression language, as well as other related standards like ODRL and ODRS. Specifically in terms of alignment, and I think some of this is a bias based on a lot of the experience, a lot of the technical members of the technical working group were specifically have a background in libraries. The alignment that we've done so far is with the premise copyright status vocabulary that was developed by the Library of Congress, in addition to the existing Europeana licensing framework. So this is just sort of an overview of how the different aspects of a right statement as presented in the white paper map to our model. So again, the majority of these aspects map directly. There are some specific things which are not mapped. One example of that is this one sentence description. It's designed to be it's not the same thing that we identify as a label, and it may be subject to change. It's more of sort of an internal cue for us. The disclaimer for the right statements is not mapped. And the reason why is all right statements at this point have the same disclaimer. We had some pretty contentious discussions about whether that was actually the case. If that needs to change, we can revisit that. And then finally, there's this extra metadata. So Greg talked a little bit about specific right statements that have, you can specify things like contractual restrictions, or you may have an expiry date on something with contractual restrictions, or you may have a web page or a PDF or some other structured data that documents other legal restrictions. So this is this contentious thing that I talked about, the thing where we needed the technical memo. There was a fundamental disagreement within the technical working group at some point about how to best represent this. Our opinion is that these were not aspects of the right statement themselves. These were aspects of that relate to the descriptive metadata about the object. So if you need to represent something like an expiry date, you need to bind the information about the right statement to one of our right statements to another sort of description of the right statement and say that I'm identifying this right statement with this expiry date in the context of a description of this particular intellectual object. So if that ends, if we hope that's clear, and part of the reason that we ended up having to do it that way was to demonstrate something very specific, which is people needed a way to link to web pages that displayed the expiry date information, or people needed ways to link to particular translations. This is a multilingual and multinational effort, so we needed to make sure that that was possible. There's not too much to say about the technical information, and again, just for time, I'm going to kind of gloss over this, but all the application work that we did is open source. All of our documentation is released under CC0. And again, for the sake of time, I think the transparency part of the technical work is by far some of the most important stuff that we did. Our dedication to simplicity allowed us to make really good progress very, very quickly. But overall, we had this ongoing concern that we misrepresented the work that we were doing. We were oversimplifying the work during the process. I think we're getting to the point where we have a good understanding of what we've done and are working to revise that. But one of the things that I would ask you to do from the perspective of the technical working group is we need to hear from you what tools we can provide to make it easier for you to adopt these statements. That's a separate question of that's not the same question as are we modeling the right statements correctly? It's how can we get this to integrate with your CMS? How can we get this to integrate with your digital asset management system? And who are the vendors or who are the developers that we need to be talking to assess what would make this easier for you to adopt? So, thank you.
I'm going to quickly talk about some goals at DPLA that we've identified for implementation, and then let you guys ask questions. And I'm going to keep this really quick. Okay, so in general, goals for implementation for us are not to add any new rights. So we've talked about that a couple of times today. Rights should reflect the original or source material. And to remember as cultural heritage institutions that we're in the business of sharing our collections, that we are not cultural gatekeepers, that we are instead collection stewards. There isn't always a definitive answer. Like when you go through these right statements, one of the things that we've worked with our partners as they've begun to think about how they're going to apply them is that there's not always a definitive answer. You may have to choose. Many factors may contribute to what you determine, including like your institution's risk analysis, like where you are on that spectrum may depend on what statement you're comfortable choosing, and that's okay, but hopefully there's an answer there that will fit your scenario, but it may be a different answer for another institution. As long as you're making an effort to be as accurate as possible, that's been our goal that we've communicated to our partners as we've begun to roll this out and do some training among the DPLA institutions. So the URIs allow us to easily populate the display data from the linked data endpoint. If the URIs are not included in the metadata records, if they are included, we don't need any other information. So as long as the URIs are there and we get that from our partners, then we don't need any other information. We can turn that URI into the statement text itself and then point you out to the full statement where you can read the disclaimers, et cetera. Data included in a distinct field means that we can easily find it. So this means that your rights data needs to be in a distinct field, and it needs to be a specific instance of a property, instead of one that you might say, it's the first right statement. It's we've used something twice, or the first or the last. So our goal is to have that in a distinct field. If you're using Creative Commons license instead of standardized right statements, they'll be handled in the same way as URIs. But what we are telling our partners is that you use one or the other and not both, right? Because you saw Mark's example where we had some confusion, where people were putting Creative Commons license with another statement. So you need to use one or the other. If you have the ability to use a Creative Commons license, do it. If you are not the rights holder and do not have that, then use a right statement. We can handle local right statements as well. So if you want to include other information that might be helpful to the user that is not in that standardized right statement, you can include that in a separate rights field, and we can display that information at the DPLA aggregate level. So if you want information something that might tell someone more useful information that's not standardized, we can include that. And as always, thanks for the Knight Foundation for funding this work. So I do think we have 5 minutes for questions. So do people have questions? In the back of the room.
Why the emphasis on all of the digital infrastructure as opposed to just a set of standardized textbooks that explain things to people? What does adding all the technical information behind it give us?
A lot?
Well, that's really loud. I think part of this was it was a set of requirements that were coming from Europeana. And in part, presumably, they wanted a RDF-based model to integrate with the Europeana data model. If your model for your collection management system is not RDF, that's fine. But one of the things that we want to hear is, what can we give you to adopt these statements? Do you need a consistent representation, which is a CSV, which is the URI, the label, plus the descriptive text? And what is the bare minimum? What is the ideal to ease that? So I think from our perspective, there were technical requirements that suggested that we needed an RDF model because DPLA and Europeana already have this existing RDF model for their own metadata. And we wanted this to fall in line with existing best practices for linked data rather than just providing our own sort of bespoke serialization of this data that you would have to parse a particular way. But we also realize that not everybody can use this in the form that it exists right now. Does that answer your question?
Other questions? Yeah.
Talking about the global use of this project, I noticed the presentation focused a lot on America and also in Europe. What goals do you have for implementation outside of those two continents, and how can you help?
Sure. So we've been meeting a lot about governance lately. So both the leaders and representatives in DPLA as well as Europeana have come together to establish a governance structure that we're getting ready to roll out at the beginning of 2017. And other kinds of country aggregations are going to be invited. So we have a pretty decent list, and there will be an open call, but there'll also be some very specific invites. We have people already interested in joining kind of the governing process and country-specific aggregations that we've talked to already who are interested. So there is some interest, and it's just a matter of kind of, okay, here's the governance, and here's how we're going to keep these. We're going to keep a statements working group, so like if new statements need to be added or edits need to be made, and we're going to keep a technical working group to keep thinking and refreshing the technical infrastructure as well. So we'll keep both of those, and then the chairs of those working groups will sit on a steering committee along with some leaders of these national digital libraries. Mm-hmm.
Hi, So I'm thinking specifically of the one that said, in copyright, but can be used for educational purposes. I mean, there are actually many cases where it might have not been worked out with the copyright holder, but there are many legitimate educational purposes that an end user could actually use something in copyright. And I'm just wondering if you have any insights or if there's anything either baked into the longer statements themselves or something that I can do within even the design of my digital collections to make it clear that like it's a both and kind of situation. Like as a consumer of this digital content, users have to be educated and we're trying to provide what we can, but there may be a range of legitimate cases where, at least in the US, you could use in copyright material.
That's right, and in fact, in the longer version of the statement, there is a clear description that says, this item is in copyright, but it is subject to the exceptions and limitations of your territory. So that's one way to address it. The other way to address it is to invite users to make fair uses of items, to be really clear that nothing on your website, nothing in the terms and conditions prevents a user from using those items in ways that are protected by the law. And too often, we see terms and conditions. The DIOR, that project has identified a number of institutions who have restrictive language on their website, and that contractual language, in some cases, can trump the actual underlying exceptions and limitations. So just making it clear to your users that even though this item has been identified as in copyright, doesn't mean that there are no exceptions and limitations like fair use that might apply.
All right. I think we're out of time. Thank you guys so much.